Good afternoon, everybody. Hi, my name is Matthew Bell. I'm the president of the BYU chapter of the Federalist Society. It is my great pleasure to welcome you here today to our awesome event on Habeas Corpus during wartime. We are very grateful to have amazing speakers, and just if this is your first time, the Federalist Society, we're a group of students here at Brigham Young University Law School, and conservatives, libertarians, and more importantly, we're interested in sharing ideas and debate and sharing all kinds of ideas. We'd love for you to join us. We have all kinds of neat events. Our next events include Professor Barkley on November 19th, along with the Solicitor General of Missouri, that will be talking about the Trinity Lutheran case. And it'll be a lot of fun. Professor Barkley worked at Beckett during the litigation, and the Solicitor General, who's a BYU grad, Jim Layton, argued the case. It'll be a lot of fun. Before we get started, I'd like to invite Josh to come up. And we'd like to introduce our speakers today. Great. So today we have Professor Amanda Tyler here coming from University of California, Berkeley Law School. Professor Tyler, before being a professor at University of California, Berkeley, taught at George Washington University and was a visiting professor at Harvard Law School. Professor Tyler has her undergraduate in public policy from Stanford University, as well as a magna cum laude from Harvard Law School. And we're very grateful to be here. And please welcome me, and help join me in welcoming Professor Tyler.
Our other guest today is Judge Griffith, who was appointed to the United States Court of Appeals for the District of Columbia Circuit in June of 2005. A graduate of BYU and the University of Virginia School of Law, Judge Griffith was a partner at Wiley, Ryan, and Fielding when he was appointed Senate Legal Counsel of the United States. In that capacity, he represented the interests of the Senate in litigation and advised the Senate leadership in its committees on investigations, including the impeachment trial of President Clinton. At the time of his appointment to the D.C. Circuit, Judge Griffith was assistant to the president and general counsel of Brigham Young University. So please welcome Judge Griffith.
So thank you so much. Hopefully this is on. Can you hear me? Thank you so much for having us. This is such a privilege to be here and to have the chance to talk with all of you. The point of departure for our discussion is a book that I published this past winter called Habeas Corpus in Wartime, From the Tower of London to Guantanamo Bay. And Judge Griffith and I thought, thank you, you're a great advertiser. We thought that maybe I would talk a little bit about why I wrote the book and some of the big ideas or theses of the book, if you will, or lessons from the book. And then we're going to have a conversation about some of the different moving parts in the book, and also, importantly, hear from the judge about his experience on the D.C. Circuit in dealing with some of the litigation that has followed, quite a lot of litigation that has come to his court in the wake of the Supreme Court's decision in the Boumediene case, which is discussed in the book. So the book is the culmination of many years of research, but it actually, the genesis for this whole line of work for me goes back to before I was a law professor, when I was in law practice. And before I was a professor, I worked at a law firm called Sidley & Austin in Washington, D.C., and I did a lot of appellate work. And one of the things that Sidley does is they work with a lot of federal public defenders to prepare their cases for the Supreme Court. And in that capacity, I had the opportunity to prep and moot the public defender who argued Hamdi versus Rumsfeld, which is a central case to all of my research and a central case to the book. The case involved the question whether President Bush could detain an American citizen as a so-called enemy combatant without charging him with any crime, without giving him a trial, as part of the war on terrorism, and in the absence of a suspension of habeas corpus. And what you may know is that the Supreme Court in that case, in a plurality opinion written by Justice Sandra Day O'Connor, held that there is effectively no constitutional bar to this nation holding one of its own citizens as an enemy combatant, that is to say, in this particular posture. Now, when I was mooting Frank Dunham as he was preparing to argue this case, having not done all the things I've done in terms of research in the many years since, I had an intuition. I was really bothered by the idea that the government could take a citizen and hold them in this posture, and they would never get a trial. In effect, they are being held based on executive branch assertions that they are dangerous. And that struck me as a very dangerous proposition in terms of thinking about it from the perspective of knowing the history of the Constitution and knowing that the founders took liberty as such a centrally important value and principle, and indeed wrote a Constitution to try and protect it. So then I went to the oral argument, and the oral argument, watching it, was all about general theoretical principles, the separation of powers, and larger questions about wartime and whether the Constitution should mean something different in times of war. And this is a court, this was 3 years after 9/11, so we were all very much in this country still thinking about how devastating 9/11 had been, and that was very influential. But what struck me as I watched the arguments was that no one was talking about history at all. And that was really odd, I thought, because it's inconceivable, I thought, correctly, that the question, what is the scope of executive power to detain during wartime, had never arisen before, right? So our Constitution was written in the wake of a war for independence. We've had the Civil War. All of this was written against the backdrop. World War II, we'll talk about, I hope, a lot today. The Constitution itself was written against the backdrop of a lot of wartime periods in English legal history. Surely this question had come up, but there was no discussion of it. And only limited, well, not limited, but a fair amount of discussion of that history comes out in a dissent in Hamdi written by Justice Scalia, joined by Justice Stevens. Well, at that point, I'm on the way to becoming a professor, and I'm super interested in this topic. I think there's a lot of historical work to be done, and I've seen an opinion that pairs Scalia and Stevens, which, just in case you aren't keeping track, didn't happen a lot. So I knew there was something really interesting here, and that's how I got launched on this line of work. And so all these years later, I have written this book to try and tell that whole story, starting in England in the 1600s, tracing the development of the origins of this concept of the privilege of the writ of habeas corpus, and walking that story through all of these moments of stress in Anglo-American history. So the Jacobite Wars, when the Stuart line was trying to get reinstated on the British throne, there are multiple suspensions. The English Habeas Corpus Act is enacted right before this, and then is suspended during these periods. The American Revolution, when very few people know, there was a suspension of habeas corpus to address the American rebels. The early administrations of Washington and Jefferson, when they had to deal with insurrections, and Washington never for a second contemplated suspending, but always told his military officials, you have to work with the civilian authorities and try suspected traitors in the criminal process. Jefferson, who wanted a suspension to deal with the Burr conspiracy, but when the House wouldn't give it to him, he turned over prisoners that had been taken into military custody for criminal trial. The Civil War, when Abraham Lincoln clearly had to confront very serious issues.
Be careful here.
Okay, be careful. The judge knows that I have some mixed views about Lincoln. Lincoln got out ahead of his Congress and suspended habeas on his own, and I argue in the book that that was a mistake, that suspension is a legislative power. It always was from its origins, and it's a power that is wrapped up in a legislative power to control the executive. So the idea that the executive would get ahead of that is a little troubling, and not that far removed from a president labeling someone as an enemy combatant. But Lincoln did understand his history, and he knew that he needed to suspend habeas to hold Confederate sympathizers and even Confederate soldiers outside the criminal process. And then we get to World War II, and that's where things really seem to go off the rails. And this is the part of my study that made me finally actually want to do a lot more work. I'd written a number of articles and write a book. Because in World War II, as you well know, we have the Japanese-American internment. We have over 100,000 Japanese Americans taken from their homes, ordered to report to assembly centers and ultimately so-called relocation centers. I'm going to call them internment camps. For an average stay of 3 years, over 70,000 of those people were natural-born American citizens. and there was no suspension. So if you look at that episode and you look at Hamdi and you don't look at the past history, you might think it's okay for the government to hold American citizens outside the criminal process without ever suspending habeas. But there's a clause in the Constitution that says we have very strict limitations on suspension. You can only do it in times of rebellion or invasion when the public safety may require it. And presumably that clause was meant to do something. Presumably because it's in the original body of the Constitution and not the Bill of Rights, this was really important to the founding generation. So what I try to do in the book is go back and uncover all of this history to tell a much richer story than has ever been told about what the founding generation thought that clause was doing. And what I find is an unwavering view, born out of English tradition, that the whole point of suspension was to empower the executive to detain citizens outside the criminal process and others who could claim the protection of domestic law, sometimes aliens. But the whole point of suspension was to give the president the power to do this. And the assumption, the working assumption, and the other thrust of the suspension clause was the president can't do this unless there's a suspension. And that's what makes the World War II period so distressing to anyone who cares about the Constitution. I didn't know this going into doing that period of research. I knew that on its face there was something very problematic about it. But what I found when I dug into it, and this for me is the most powerful part of the research that I've done, is something really troubling. Namely that a number of very prominent officials in the Roosevelt administration, including the Secretary of War and the Attorney General, recognized immediately when internment was proposed that it would violate the suspension clause. That is to say, unlike the way we talk about internment today, and you should talk about it through this lens of discrimination, at the time, the case law had not developed to where discrimination and equal protection were principles that constrain the federal government. That doesn't come until 1954 in Bowling versus Sharp, after Brown. But in 1944, when the Supreme Court has Korematsu and Endo and the year before Hirabayashi in front of them, they really don't take these discrimination arguments seriously because the jurisprudence hadn't gotten there yet. But the suspension clause jurisprudence was there. And the Supreme Court never talks about it, which is itself very interesting. But the Attorney General, the moment that internment was proposed, said to the President, said to Congress, said to anyone who would listen, if you do this, I'll quote directly from him, unless the writ of habeas corpus is suspended, I do not know any way in which Japanese born in this country, and therefore American citizens, could be interned. That's pretty unequivocal. Now, he was the son of a law professor and the descendant of a very important founder who was involved in the ratification debates. So he knew his history. But he wasn't alone. A lot of other lawyers knew it too, and they told the president repeatedly, you can't do this. But in writing about this period and uncovering these debates and conversations, what I found was a quote from a senior War Department official that I think really explains what happened. And he said in a very heated debate with the Justice Department, if it is a question of safety of the country, the Constitution of the United States, why the Constitution is just a scrap of paper to me. And that is a quote that is really emblematic of the mindset that set in and set in motion all of these events that resulted in the internment, one of the worst constitutional violations in our country's history. And so I think there's a larger lesson here that the book tries to lay out, both in telling the history, but also uncovering where the story changes and shifts gears. And it's the Japanese-American internment. And that's really where the groundwork is set for a case like Hamdi and our modern thinking about the suspension clause, which has nothing to do with the historical ideas that were at the core of the clause. The idea, of course, was you can either do this with suspension within the constraints of the Constitution, or you can't do this at all. So if you brought a habeas petition, the remedy was discharge, not more process. We're going to talk a lot about the remedy of more process. That's not how the framers thought about it. That's not how people thought about it until World War II. And so there are really important questions about history, the role of history in interpretation. What do we do about changed meanings? And there's an interesting counter story here about an evolving constitutional meaning that takes away liberty, that goes below what the constitutional floor was at the founding. That's a very sort of counterintuitive story when we think about methodology in constitutional interpretation. And there's a really important story in this particular period, World War II, about the role of government lawyers and the rush to put interests of national security above all other interests, including liberty, which the Constitution was written to protect. And in all of this, it's also a story about the meaning of the Constitution in wartime. And the suspension clause, what I try to argue, is really at the center of that conversation. It isn't typically, but it should be. Because as Justice Robert Jackson once said, it's the only express emergency provision in the Constitution. And it was written specifically to empower the executive to deal with emergencies. So that's what the book is about. That's the inspiration.
So I came upon the book. Professor Tyler invited me and a number of other judges to a conference that was held at Berkeley last spring about the book. And like you, I have too many books that I haven't read. And while you have to read case books, I have to read briefs. And I don't get much time to read books. But this is a book that, first of all, it's extremely well written. How many legal things that you read that are actually enjoyable to read? This is one of them. Professor Tyler is a great storyteller. And it touches upon, first of all, it deals with one of the biggest issues that exists, right? National security versus individual liberty. And there, you're talking about something that's as deep as humankind. The whole tug and pull between safety of the tribe, autonomy of the individual. It plays out in this way, in a major way in the book as she tells the story. For this group in particular, the Federalist Society, this is a book that originalists ought to devour, right? Because it's an important work of history. And if you believe, like I do, that the role of a judge is not to come up with wonderful policy judgments based on my own sense of right and wrong, but instead to apply the law as it exists, to try and figure out what's the value chosen by we the people and put in the Constitution. You can't, that's why the story about the argument at Hamdi is so shocking. You can't do that unless you have some fundamental sense of what the writ of habeas corpus meant in 1789. And Professor Tyler's book is the finest exposition of that exists. So it's a work that originalists ought to be interested in. Now here's the surprising thing, originalists, Federalist Society originalists, the executive branch isn't always right. Now I know that may be shocking to some of you Federalist Society folks, but it's not always right when it comes to matters of national security. I read it because it was interesting, because it actually affects my work on the DC Circuit, because we, less so now, but in the last decade we had a fairly active Guantanamo Bay docket. What you get from this book is not just a description of the history of what the writ means and how it's been applied, but it's the story that you're going to get to. This is a professional responsibility class as well when you read this book, because at the end of the day, you have individual actors hopefully acting out of their own sense of what's in the best interest of the public. But time and again, when the issue is national security versus individual liberty, it's individual liberty that gets shortchanged. And so you and I, as citizens, need to think through, are we comfortable with that? Is that the bargain that was struck by the founders that's enshrined in the Constitution? Or have we ignored the bargain they struck in favor of our own sense of what's a better way to balance individual liberties and national security. So, would you tell the government lawyer story? Is this the time for that?
More from World War II?
Yeah.
Yeah, I think it's really very troubling to me during World War II that you have a number of prominent government lawyers who know very much that the suspension clause precludes the ability of the president to do this. And they know this, meanwhile, because the first thing the government did, very few people know this, after the bombing of Pearl Harbor, that afternoon, habeas corpus was suspended in Hawaii. And the Secretary of War, in the months that followed, actually, and this is a trend, a sub-theme, subplot, if you will, of the book, moved prisoners around in light of that, knowing full well that it would be legal to hold people outside the criminal process in Hawaii where there was a suspension, but not on the mainland. And then within a matter of months, by February, so December 41, you have the bombing. By February, President Roosevelt issues 9066. And then he says, effectively, to the War Department, you have carte blanche to do whatever you want. And over the next 3 to 4 months, a number of military regulations are issued that ultimately result in people going into internment camps. But throughout, you have government lawyers who are saying, at least early on, you can't do this. This would be unconstitutional under the suspension clause. And the War Department officials, including the Secretary of War, who very clearly understood this, and in his diary wrote, citizenship matters, we can't do this with respect to citizens. He's clearly very anguished about it, but he ultimately, and the president, oversee this. And the Attorney General, who keeps making this argument, at one point goes to lunch with Roosevelt and says, best I can tell, as long as you run this out of the War Department and my name's not on it, it's okay. He stops making these arguments. And everything unfolds. And then there are some really even more troubling aspects to the story. And this is another real failing on the part of the executive branch. In the months immediately preceding and following Pearl Harbor, as you can imagine, the military and other intelligence services were doing extensive investigation on the West Coast into whether there was a threat posed by Japanese Americans. And a number of studies, extensive studies, had looked into this and had reported well before President Roosevelt issued 9066 that there was no threat posed by Japanese Americans. There were a handful of potential bad eggs. They were either in custody or under surveillance. And so all of that was also known to all the relevant actors in the lead up to 9066 and in the months that followed while these regulations are being issued. And even J. Edgar Hoover, I love to tell this part of it, who was no stranger to robust surveillance, let's be honest. Even he said to the president and the attorney general and whoever would listen, there is no factual basis for this. This is based on public hysteria. And nonetheless, everything goes forward.
If there had been a communist amongst them,
that would have been different. That would have been different. Or Martin Luther King. Right. So, I mean, it's important that you know Hoover was not light on this stuff. And he even said, this is absurd. And the Attorney General said to the President in the days leading up to this, the hysterical reporters who are publishing these ridiculous stories about the threat of Japanese Americans, either they know something the entire military and intelligence services don't know, or they are behaving incredibly irresponsibly. And it's pretty obvious that it was the latter. Everything gets rolled out anyway. And then the final sort of added insult of all of this is that when Korematsu and Hirabayashi and Endo, the three major cases, there's also a fourth, Yasui, are argued to the Supreme Court during World War II, some lawyers in the Justice Department who were pushing back on this and who litigated in Hawaii and litigated elsewhere with great distinction and honor, they said to the Solicitor General, we have to include a notice in the Korematsu briefs that there are serious factual problems, that there has been no proof of a military necessity for this. And when that brief was at the printer, the Solicitor General ordered the footnotes stricken and the brief reprinted. So all of this is presented to the Supreme Court in the context of the Solicitor General arguing, saying there are huge national security issues here. The executive branch has determined there's a grave threat. You, court, need to defer to us. And of course, that's what the Supreme Court did. And these arguments are not new. They are arguments that we see every time we are in a wartime or stressful period. Defer, the executive branch says to the courts, to us. We know the facts on the ground. But this is a story that should give great pause to anyone who reflexively embraces that argument. And in Korematsu, Justice Jackson at one point says, there's never been any kind of hearing. There's been no fact-finding about any of the underlying assertions that are the predicate of all the policies that were put in place. But it's of no moment. And so that's another important lesson, I think, for judges.
Let me ask you to play anthropologist for a second. Why is that the case? And was the Japanese internment really that different than other moments where we've resorted to, where we've thrown up the protections of the criminal law and allowed the executive to run roughshod of the Constitution?
No. So the Civil War is another example. And I think that the two classic examples, people might, and I think I probably would also put the War on Terror, at least in part, under the same umbrella. But in the Civil War, there were cases challenging the use of military tribunals to try and convict civilians that also implicated habeas issues that came to the Supreme Court during the war, and they claimed to have no jurisdiction over them, which is really curious because they took just such a case 1 year after the Civil War, Milligan. And in Milligan, you see the Supreme Court hand down a very liberty protective decision. It's a really important decision. I hope you all will read it in class, and if you don't, you need to read it on the side. And it's really long. If you want an edited version, email me. I'll send you what I give my students. It's a really important decision, but it comes after the war. And in World War II, there's another really important decision that we never teach our students called Duncan that comes a year after the war. And Duncan gets lost in translation somehow. It revives all the reasoning of Milligan and says there are real limitations on what the government can do, and the Constitution does not mean different things in times of war and in times of peace. But for reasons that perhaps we might understand, but I think it's fair to be critical of, the courts have never been comfortable standing up to the executive during wartime. And that's a really interesting thing. And another interesting contrast that I would highlight just from the World War II example, and the book, I should say, that's just one chapter. It's about a lot of other periods, but there's a lot in that period to talk about. I thought I would say a word about Churchill.
Okay.
Because during World War II, across the Atlantic in England, as you can imagine, they're dealing with all the same issues we're dealing with. They're concerned about the threat of enemies within, so-called fifth column activities, German sympathizers, enemies within our midst, if you will. And they do also have a citizen internment program. It's run under Regulation 18B. What's interesting about that program, and there are a lot of interesting things about it, but the one thing I want to highlight is as the war is really, really bad, conditions are really, really bad in England in 1943, and even earlier, Churchill becomes a critic of that program. And it's because of Churchill that that program was really wound down and ultimately ended. And he said to his Home Secretary and other ministers, this is at odds with all of our traditions. This is at odds with the great British tradition of heralding habeas corpus and trial by jury, and we ought to get out of this business. And in a really poignant passage in one letter to his Home Secretary, he says, ministers who are not prepared to defy public clamor, that is to say, defy public opinion, are not fit to be in their positions in times of national stress. What a different message. I'm not saying Churchill was perfect, but what a different message than Roosevelt just rolling over and giving military officials everything they asked for.
How do you explain the difference between the two? The obvious one is the racial component. Right?
Yes.
Would Churchill have reacted the same way if there was the racial component?
I don't know. But he had two cousins by marriage who had been interned. So it clearly resonated with him in a way that the Japanese Americans' plight did not register at all with Roosevelt. I think another tradition that is different, if you talk to people in Britain about the way they think about the British Constitution, they think Parliament is a really central component to the protection of British liberties. They do not reflexively, as we tend to do, look to the courts. And there's nothing wrong with our tradition per se, but the president takes the same oath. We both have our pocket constitutions here. The president takes the same oath to uphold this Constitution. And so I think one of the lessons that I like to say to students when I talk about this period is, you're all going to go and be lawyers and government officials, I hope, in a lot of different branches of government. Remember this story and think about the important responsibilities that you will have in those positions. And don't just think the Supreme Court will take care of it, as Roosevelt once said. We all have a responsibility to honor the Constitution and to try and work within its framework. That's our country at its best and our profession at its best.
And I'd like to address that, if I can, in terms of what's happened on the D.C. Circuit in the wake of Boumediene. Do you pronounce it Boumediene or Boumediene? I'd say Boumediene, but...
That's how I say it, but I don't know whether that's right.
French. So let me tell you quickly a little of the history about the Boumediene case. There was a trilogy of Supreme Court cases that made their way to the Supreme Court through the D.C. Circuit. And in each one of them, detainees at Guantanamo were trying to get the federal courts to challenge their confinement. A quick story, because I think it's an interesting one. The first case that made it to the Supreme Court was in 2004. It was called Rasool. And the question was, does the Habeas statute entitle Guantanamo detainees to challenge their confinement? And the D.C. Circuit said no. The Supreme Court said yes. And Congress overturned the Supreme Court in the Detainee Treatment Act of 2005. Okay, next case that comes along, the Hamdan case. You probably think Hamdan's assigned to most reading. Comes for the Supreme Court in 2006. Related issue. There's the Habeas statute entitled Guantanamo detainees to challenge their confinement in federal court. Comes the D.C. Circuit. No way. Goes to the Supreme Court. Yes. And then Congress gets involved in the Military Commission Act of 2006, overturns the Supreme Court. So far, the D.C. Circuit is over 2, and 3 strikes, you're out, right? So it's 0-2 count. What are you looking for now? You're looking for something in the dirt, a high fastball? The next case comes along is the Boumediene case. This raised the question of whether the statutes that Congress had created depriving the federal courts of jurisdiction, because Congress was clear. Congress did not want any habeas protection for alien enemy combatants. Do those statutes violate the suspension clause? D.C. Circuit, no. Same judge in the majority opinion every time, Judge Randolph. D.C. Circuit said no, because in the Habeas Corpus Act of 1679, which is the template by which you look at what was going on in 1789, it was clear that the writ did not extend beyond England's sovereign territories. Guantanamo was not part of the United States, therefore, no. The Supreme Court said you're wrong again. 3 strikes, you're out. And that's the Boumediene case. And since that time, the D.C. Circuit has handled a lot of these cases. Now let me give you my critique of Boumediene. This will show you I am confident. I have no confirmation hearings in my future. In fairness, Boumediene raised some novel issues.
Yes.
One is Guantanamo part of the United States. That's maybe a tougher issue than we had thought before. Second, what is the status of these detainees? They weren't regular troops that fought in war. They were working for ISIS and others. How do they fit into this mix? Are they like pirates before? What are they?
Yeah.
They're tough issues. But my critique of the Supreme Court is that it made 2 fundamental mistakes. One, I think it was wrong on the law. There were dozens of amicus briefs that were, and you may disagree with me on this, there were dozens of amicus briefs that were filed in the Supreme Court by academics, all in favor of the detainees. But no one was able to cite a single case or any contemporary commentary from the 18th century indicating that habeas reached beyond the nation's sovereign territory in 1789. So I think we got it right. The Supreme Court disagreed. They're the final word. That's not as bad as I think what happens next. I think Boumediene represents a fundamental violation of the separation of powers. Because what the Supreme Court did in Boumediene is said habeas rights extend to these alien enemy combatants in Guantanamo, and you, lower courts, figure out what that means. And so that's what's been happening in the decades since then, is the lower federal courts, and we get the lion's share in this case, are supposed to be figuring out what habeas corpus means in this setting at this time. And to me, that's of a piece with a larger criticism that I have of the Supreme Court, and that is that it has stepped outside of its lanes. This is, as Professor Tyler, I think, demonstrates persuasively, but the issue of national security and individual liberty, this is, and particularly when it comes to the writ of habeas corpus, this has always been worked out involving the political branches. Congress has been, the representatives of we the people have always been the ones to try and figure out the balance. With Boumediene, the Supreme Court has once again said no to that, and has said the courts have to be the ones to figure it out. And I, for one, as a judicial conservative, am really uncomfortable with the courts arrogating to themselves that sort of power instead of allowing or requiring the political branches to work it out. Now, we may disagree with that latter criticism.
I'm not sure we do.
Okay.
I think what I would say is, I'm not sure we agree on every aspect of Boumediene, but we agree on a lot, which is to say the book is a book about history, and there is no historical predicate for what the Supreme Court did. So that's important. Classic model of wartime, this is what happened in the American Revolution, is if you have people who can claim the protection of domestic law, citizens being a primary example, you had a choice when there were suspected traitors, even in wartime. This is what the English Habeas Corpus Act established. It's what the suspension clause embraces. You can either try them criminally, or you can suspend habeas and then hold them in a preventive posture, like a prisoner of war. For foreign enemies in a declared state of war, like the British viewed the French during the American Revolution, international law governs, and it allows for the taking of prisoners of war. And you can hold French prisoners as prisoners of war for the duration of the American War for Independence, as the British did. That doesn't map onto this problem, and that's a big reason why there is no historical predicate for it. It is also the case that the English Habeas Corpus Act only applied in Britain. It didn't apply in the American colonies, which very few people know, but I try to tell the story in the book, was one of the moving parts of why the American colonists wanted independence. It wasn't just taxation without representation. There are a lot of references to being denied the Habeas Corpus Act. So historically, there were allegiance issues and geography issues, but there was a very fixed framework that doesn't map onto the modern problem.
So what's the court supposed to? I'm critical of the
I
court.
don't know. I mean, that's
the court moving into that area and trying to solve the problem.
So what I say in the book is this is not a suspension clause problem, because the classic remedy for the suspension clause that has been totally gutted and watered down is discharge. It's not more process. So I say in the book, Boumediene reads to me like a modern due process case. Now, an originalist is not going to like that because they don't like modern due process. Someone who believes in an evolving constitution might be more comfortable with it, but it reads in a...
There's the irony there.
Right.
Here we have an example of originalism supporting a progressive outcome, perhaps, right?
Definitely in Hamdi.
Yeah,
I mean, that is
exactly.
the great irony, is that the originalists have the more progressive outcome in Hamdi with an American citizen, Padilla, the other case that was pending at that time. They have the better of that argument. And it's Justice O'Connor who writes in Hamdi, well, we have to balance national security against individual liberty. You don't do that in this context, at least historically, certainly with a citizen.
I would argue the balance has already been struck.
That's
It was struck
right.
in the suspension clause. You don't get to
That's right.
rejigger it later.
The only figure of the government who gets to change it is the legislature, Congress, if there's a rebellion or invasion, and in no other circumstances. The Constitution is quite clear.
Whatever else you might say about the war on terror, it doesn't fit into
It doesn't
it's not
fit.
rebellion or invasion.
It doesn't fit. And on this note, I want to say the justices have been very interesting. And if you go back and you read Hamdi, I'm giving you all this homework, I'm sorry. If you go back and you read Hamdi, you've got to read Justice Thomas's opinion, because he's a self-avowed originalist. That opinion is deeply troubling from an originalist perspective, because he has a portion near the end where he says, Justice Scalia's view, it sort of puts the government in a straitjacket. You either suspend, which is super dramatic, or not, and he says it's not clear the war on terror qualifies as a rebellion or invasion. And then he says that's really problematic because it would have the government acting unconstitutionally in trying to protect us, which inevitably they will have to do. My response to that is, that's really interesting, but the Constitution is what the Constitution is. And an originalist should care more about what the founding generation thought. And they meant to make this tough because they knew it could be abused.
Which all goes to show, in my way of simplifying this, is that when you're dealing with issues of life and death, of national security and liberty, those are the most difficult issues to grapple with. And we don't always give our best thinking to that, right?
I think that's right.
There's tribalism going on, there's fear that's going on, and it seems to me the role of the Constitution and the role of lawyers is we're supposed to be participants in that process who say, calm down, let's get the facts, let's think this through as best we can. Unfortunately, the history that you lay out show that doesn't happen.
No.
Very often. More often what happens is the sense of fear, the sense of the tribe overwhelms the sense of liberty. So, is that unfair? Or
I think that is fair, and I would say that my book, the hope of the book, and other work like it, is that when we face these new chapters of similar crises, that people will take stock and they will pause and they will read the history. That my hope is, as an academic, I've done work that will be helpful when we have the next Hamdi, because we will. We know from history this issue will come up time and again.
People don't do well under fear. As lawyers, we need to be the ones to be the rational person to point that out. So we're out of time, so I guess it's a question. Thank you.
Yeah.
Will be some questions?
Thank you.
But we're out of time for us, but now we're time for questions. Is that right?
Yes.
Okay.
We have. We'll be passing around. If you want to raise your hand, and we'll call.
A lot of this, as you've alluded to, comes down to the branch's reluctance to exercise their obligation to checks on the other branches. What do you think needs to happen in the government for the respective branches to exercise that right?
I think it's important that lawyers be a part of the conversation anytime we're talking about doing something that implicates potentially the Constitution. I think it's important that lawyers not give reflexive and uninformed advice. And I think it's important that government leaders who are in a position to shape policy listen to thoughtful and well-informed advice and internalize it in a way that doesn't often happen. And I think, if we could talk about the war on terror, there was advice given early on to the Bush administration to try and work outside the law. And I think that's part of the story that leads up to Boumediene. There are other ways the Bush administration could have addressed the Guantanamo Bay detainees and not wound up with the loss that they suffered in the Supreme Court. So Jack Goldsmith, who was in the administration for a period and has written this great book called The Terror Presidency, he says in there, and I think he's right, that if the Bush administration had taken less of a hard line on the application of international law, at least in some respects, to the detainees, the Supreme Court would have been more reluctant to get involved. And I think it did get involved in an area where it was making new law, and it fumbled, and it didn't give much guidance. But part of the reason I think, and I say this in the book, I think it did this, is because it thought it was encountering an administration that was saying no law applies. And for someone like Anthony Kennedy, that's not going to fly. right? So there are, it's not just getting it right, which I think should be the first thing that all government officials should think about, the Constitution being the cornerstone of our government and our society, but it's also about thinking, is this, even if you want to take a hard line, is this the right approach in the long run? And you need to think about the precedents that actions set for the future. You know, there's a famous line in Jackson's dissent in Korematsu where he says, the court never should have taken this case if we were going to affirm sending people to these internment camps based on being Japanese American, because now this is going to lie around like a loaded gun, ready for the hand of anyone who wants to pick it up. And that's a really prescient and poignant observation.
Yeah, I've just add, the premise of your question is a good one, that we need to understand that there are roles to play, right? So in the culture of most folks here, there's a story that was told when David O. McKay was on his mission to Scotland, right? And it's up in the MTC. Do you remember the piece of the archway of a door that he saw, whatever thou art, act well thy part? That's the message to the branches. You need to understand, I'm a process guy. You need to understand your role. Congress, you need to understand your role, and you have to play that role. The result is important, but every bit as important is the process by which you reach that result. Because in that process, the framers there's value in the process itself. There are values that are being protected or trenched upon by disregarding the process. So how do you get them to do that? That I don't know, except you just got to talk it up and remind people that no, you're a legislature, you have a role to play. You're a court, you have a role to play. You're an executive, you have a role to play. Stay in those lanes. And again, that's my greatest criticism one of my criticisms of the court and Rumidi and more largely is I don't think they stay in their lanes enough, and they reach over and become policymakers, and then that typically results in problems for us.
I have a question just following up with that. We rely so heavily on the checks and balances to make sure that the government is doing what it's supposed to. The fear for the future is that 2 branches or even 3 of the government are operating outside of the Constitution. Is there a better system or a revision to the system? Could we add another check somewhere to hopefully prevent these problems?
Well, it's interesting that you asked that, because I was going to chime in already and say an added element to all of this that we're not talking about is the people. And it connects back to everything we've been discussing. There's a famous quote from Charles Evans Hughes before he was on the Supreme Court when he was running for governor of New York, I think, if I'm not mixing it up, that Japanese Americans have grabbed onto. And if you read speeches that they give, including one of my colleagues, a speech her grandmother gave, this is Professor Tani, about being in the camps, they've grabbed onto this quote, and it's similar to the War Department quote I read you earlier. Hughes said, the Constitution is just a scrap of paper. He didn't argue against that premise. He said it takes people to give it life and meaning. And it takes, that's absolutely right. And that's the point that a lot of the survivors of the camps are making, is that it's not just that the government officials didn't take the Constitution seriously. The American people were all too eager to send these people, their fellow citizens and immigrants who couldn't become citizens because the naturalization laws were racist at the time, to these camps. And everyone just sort of let this happen. And you don't just have to be president of the United States or on the Supreme Court to care about the Constitution and feel like you have ownership of it. All of us do, and particularly all of us who are lawyers. So whatever you go out and do, you have to remember that this document is so important, and it has to be a part of how you think about your role in our society. There were only a very short list of lawyers who stood up and litigated on behalf of Japanese Americans. It's a really short list. And I talk about one of them in the book, and I'm doing more work on the particular Endo case. And this lawyer, his family received death threats because, God forbid, he was representing a 20-year-old Japanese American woman who was a citizen, who'd been fired summarily from her job by the state of California and sent to a camp. That's crazy, right? That's just crazy. So we as lawyers, we as the American people, and government officials, we all own this Constitution, and we all have to honor it in our actions and what we say and what we advocate for. And I think now more than ever, that's a really timely lesson.
Yeah, I don't think we need to do anything drastic except stay in the lanes and be committed to the Constitution, and each part play well their part, and that's why. But it's so important. The partisanship that's entered into it, results seem to be the only thing that matters, and whether the result is coming from the legislative branch or the executive branch or the judicial branch, it doesn't seem to matter much, and that's, I think, extremely dangerous, particularly when it's the judiciary that's becoming the policymaker. Because if you'll notice, we're not elected. We're not accountable to we the people. And if we're in a system where we have 9 wise people making decisions, Plato's a brilliant fellow, and he may have been on to something, but we chose differently. And the system that we chose is that politically accountable representatives make the law. And so no, I don't think we need to change the system. I just think we need to give it life and vitality and remind the players in the system to stay in their lanes.
Well, please join me in thanking Professor Tyler and Judge Griffith.